in the United States, whether at the state or the federal level, the court systems are organized in three tiers. These tiers constitute a hierarchical pyramid with a very broad base of many courts, an intermediate level with a smaller number of courts, and a single court at the top of the pyramid. At the lowest level are the trial courts of general jurisdiction. These are the entry-level courts that first hear a wide array of civil and criminal disputes. The trial courts of general jurisdiction are courts of record. That is, the proceedings are written down and saved by the government. In the state systems, these courts are usually organized along county lines. For example, in the state of Illinois, there are 102 counties, and each has a circuit court that serves as the trial court of general jurisdiction within the county. These trial courts have different names in different states. In California, they are called superior courts. In New York State, Supreme Courts. The nearly universal practice is for each civil and criminal case to be tried to a single judge and possibly to a jury. In the federal system, the entire country is divided into 94 judicial districts, each of which contains a federal district court, which is a trial court of general jurisdiction for the federal judiciary. Every state in the Union has at least one federal district court, and about half have only one. The District of Columbia has its own district court. The larger states, where larger numbers of disputes involving federal questions arise, have up to 4 district courts, usually organized along geographical divisions of the state. New York has 4 districts: the Southerner, the Northerner, the Eastern, and the Western. Let me repeat that sentence. New York has 4 districts: the Southern, the Northern, the Eastern, and the Western. Illinois has 3 federal districts: the Northern, the Central, and the Southern. As the volume of federal litigation has grown, Congress has responded not by creating more districts, but by appointing more judges within each district. One of the busiest districts is the Southern District of New York, which contains most of New York City. As of 2010, there were 44 district judges in that district and 15 magistrate judges. Superscript 4 reads, in the last edition of this book, there were 25 district judges in that district. Another busy district, the Northern District of Illinois, has 32 district judges and 14 magistrate judges. Superscript 5, which reads, in the last edition, there were 12 district judges in the Northern District of Illinois. Magistrate judges are appointed by district court judges in each federal district for renewable 8-year terms. Those magistrates preside over trials for federal misdemeanor crimes and hear preliminary motions in more serious federal crimes and pretrial motions for many civil cases. Magistrates may preside over federal civil trials if the parties consent. The usual procedure in the federal districts is for a single judge to hear each case, but a three-judge panel sometimes hears a case. In addition, the federal court system includes several specialized tribunals. For example, there are special tax courts and federal administrative agencies, which, such as the Federal Communications Commission, have administrative law judges who hear arguments about matters before those agencies. Uh, there is also, as we shall soon see, a special appellate tribunal in the federal system for dealing with intellectual property cases. Superscript 6, which reads, as of August 2010, there were a total of 678 federal district court judges, 179 Court of Appeals judges, 9 judges on the Court of International Trade, and 9 justices of the United States Supreme Court, for a total of 875 federal judges. There are currently 98 vacancies 98 vacancies in the federal judiciary because Article 3 of the U.S. Constitution provides for these judges. The 875 federal judges are called Article 3 judges. Above the trial courts in the state and federal systems are appellate courts or courts of appeal. In most state court systems, there is only one court of appeal. But about 1/3 of the states and the federal system have intermediate appellate courts that stand between the trial courts of general jurisdiction and the highest court, a court of last resort. For example, in Illinois, there are 5 intermediate appellate districts with a total of just over 50 justices. Where these courts exist, parties from the trial court may appeal as of right, which means that so long as they are willing to pay the costs involved, the parties may not always seek appellate review of a lower court's judgment. Appeal is also a right in the federal system, at least from the district courts to the intermediate courts of appeal. Well, there may be a right for either party to appeal the judgment of the trial courts of general jurisdiction. Matters may be different if either party wishes to appeal the judgment of an intermediate appellate court in both the state and the federal judiciary. The highest appellate court typically has a discretionary right of review. This means that the Supreme Court of Illinois, the Supreme Court of the United States, and all the other courts of last resort may select which cases they will review. Within certain limits, some cases, for example, disputes between 2 states, come to the United States Supreme Court directly and without the discretion of the judges. And in many states, the highest court is obligated to review death sentences. Thus, the United States Supreme Court and the highest courts in the states control most, but not all, of their docket.